case of parents and children. If it is between a parent and a child, it can either be legitimate or illegitimate. The relationship must be by blood, except in case of spouses. And the relationship must be in the direct line. So this is the kind of relationship that will qualify the killing to parricide. On the other hand, under Article 248, the law punishes murder. Murder is committed when the offender kills another person and the said act of killing doesn't amount to parricide or infanticide, and the said act of killing is attended by any of the following qualifying circumstances. First, if the killing is done with treachery, taking advantage of superior strength, with the aid of armed men, employing means to weaken the offense, employing means or persons to ensure or afford impunity, or when the killing is done in consideration of a prize, reward, or promise, or if the killing is done by means of inundation, fire, poison, explosion, shipwreck, stranding of a vessel, derailment or assault upon a railroad, fall upon airship, by means of motor vehicle, or by any other means involving great waste and ruin. Or if the killing is done on the occasion of the calamities I mentioned, or on the occasion of an earthquake, eruption of a volcano, destructive cyclone, epidemic, or other public calamity. Or if the killing is done with evident premeditation, or if the killing is done with cruelty, by deliberately and inhumanly augmenting the suffering of the victim, or outraging or scoffing at his person or corpse. So, murder is the act of killing another, attended by any of the qualifying circumstances mentioned in Article 248. Provided it will not amount to parricide, it will not amount to infanticide. If the offender kills another person, not amounting to parricide, not amounting to infanticide, and is not attended by any of the qualifying circumstances under Article 248, the crime committed is homicide under Article 249. So we have parricide, we have murder, and we have also homicide. So what if the offender or X had a fight with Y? In the course of the said fight, since X was losing the fight, X pulled out a knife and stabbed Y with intent to kill. Indeed, Y died. What crime is committed? The crime committed is homicide. It is not attended by any of the qualifying circumstances under Article 248, therefore it is homicide. What if X and Y are brothers, and X wanted to terminate Y? He wanted to be the sole heir in the family. And so, he invited Y to have lunch in their house, promising Y that he would be preparing his favorite dishes. So Y arrived in the house of X. Not only Y was accompanied by his wife and his 3 children. And, true enough, X prepared the favorite dishes of Y, and everything was on the table. And so his wife and the 3 children ate the food. After eating, the entire family of Y died. Unknown to them, X placed poison in the said dishes prepared by X, him wanting to kill Y. What crimes had been committed by X? X is liable for the crime of multiple murder. It is not parricide, although X and Y are brothers, and although the relationship is by blood, and although it is legitimate, because the relationship between siblings is not in the direct line, but in the collateral line. And since the act of killing was done by means of poison, therefore it is murder. And since there are 5 persons who died by a single act of placing poison on the food, we have the complex crime under Article 48 of multiple murder. The husband and the wife are childless, and so the husband and the wife filed a petition to adopt W. The said petition for adoption was granted, and so W is now their child. One night, W arrived home very late. He was scolded by the father. And in the course of the said act of scolding, there was a heated argument because the said son W answered back at the father. And in the course thereof, the father lost so much control of himself that he was able to stab his son. What crime has been committed by the father? Is the father liable of parricide? Is the father liable of homicide and murder? The father is liable of homicide. It is not parricide because although under the family code, being adopted is now akin to a legitimate child, still the relationship is not based on blood because he was in reality merely adopted. Since the relationship was not based on blood, and since the said act of killing was not attended by any of the qualifying circumstances under Article 248, the crime committed by the father would be the crime of homicide. What if the husband arrived home? When the husband arrived home, it was not the usual time that the husband arrived home from work. Usually, the husband arrived home from work every 8 o'clock in the evening, but at that time, he has to get out early to under time because he was not feeling well. And so the husband went home early. The wife didn't know that he would be arriving home early. The husband entered the house and was about to immediately lie on the bed, and so he opened the bedroom. But upon opening the bedroom, the husband saw his own wife in actual sexual intercourse with another man. That man happened to be the friend of the husband. And upon seeing that, the husband was so sad, in pain, full of jealousy. He immediately went to the kitchen, and upon coming back to the bedroom, he stabbed the said friend to death. Thereafter, he went to the police and he surrendered. What crime or crime should be charged against the said husband? The husband should be charged with a crime of homicide. He killed his friend. What if you are the counsel for the said husband who is charged with homicide? What would be your defense? Your defense would be Article 247, that is death under exceptional circumstances. What if you were the judge who would rule the case? How would you decide a case? If you were the judge, you have to convict the accused husband of the crime of homicide. But instead of imposing the penalty of reclusion temporal, the penalty prescribed for homicide under Article 249, you only have to impose the penalty of desterro as provided for under Article 247. 247 is applicable. There are two stages in Article 247, death and serious physical injuries under exceptional circumstances. First, that a legally married spouse surprises the other spouse in the actual act of sexual intercourse with another person. It is present. The husband, a legally married spouse, surprises the other spouse, the wife, in actual sexual intercourse with another man, his friend. Second stage, that the said legally married spouse kills or inflicts serious physical injuries upon any or both of them while in the actual act of sexual intercourse or immediately thereafter. Right after the surprising, the husband felt pain, jealousy, lost control of himself, took the knife, and then thereafter stabbed to death the said paramour of the wife. Therefore, the said killing took place right after or at the time of the said sexual intercourse. Hence, in that case, Article 247 would lie in favor of the said husband. Supreme Court said, Article 247 is not a felony. Article 247 is akin to an absolutory cause because instead of being imposed with a penalty of reclusion temporal for homicide or reclusion perpetual for murder or prison correctional for serious physical injuries, the penalty to be imposed is only desterro. Supreme Court said desterro is not in effect a penalty, but it is an act of protection by law on the part of the said accused for any retaliation coming from the family of the victim. So Article 247 is a matter of defense. It is an absolutory cause and it is not a felony. So here the judge would convict the husband of the crime of homicide and impose upon him the penalty of destierro instead of reclusion temporal. What if the husband arrived home? When the husband arrived home unannounced, he went inside the bedroom and he was shocked, he was surprised. He saw his wife in actual sexual intercourse with another woman, the nanny of their child. And he was in pain. He never thought that his wife would be like that, would have sexual intercourse with another woman. He was enveloped with jealousy. He took a knife and then he stabbed the nanny to death. He surrendered. Of what crime should the husband be accused of? The husband should be charged again with the crime of homicide. It is homicide because the killing of the said nanny was not attended by any of the qualifying circumstances under Article 248. It happened at the spur of the moment. Therefore, it is homicide. If you were the counsel of the husband, what would be your defense? You can put up Article 247. You can also raise several mitigating circumstances such as voluntary surrender, sudden impulsive passion obfuscation, immediate vindication of a grave offense. If you were the judge, how would you rule on the case? If you were the judge, you have to convict the accused as charged of the crime of homicide and impose upon him the penalty prescribed by law for homicide. Article 247 this time would not lie in favor of the husband. The term sexual intercourse under Article 247 does not include homosexual intercourse. So the said sexual intercourse refers only to a wife having carnal knowledge of having sexual intercourse with another man, or to a husband having sexual intercourse with another woman than the wife. But it doesn't refer to the wife having some homosexual intercourse with another woman, or the husband having homosexual intercourse with another man. This refers only to a man to a woman to a man. It doesn't include homosexual intercourse. So in that case, the judge has to convict the accused as charged for violation of Article 249 homicide. Article 247 does not apply, therefore he has to impose the penalty prescribed by law, homicide. For homicide, that is reclusion temporal. However, the judge can consider several mitigating circumstances. We have voluntary surrender, and we have also sudden impulsive passion obfuscation. Although, as we discussed yesterday, the other day I mean, both mitigating circumstances of immediate vindication of a grave offense and sudden impulsive passion obfuscation are present, the judge can consider them only as one mitigating circumstance, so as to lower the imposable penalty. Articles 251 and 252 are both about tumultuous affray. Under Article 251, in case of death in a tumultuous affray, there are several persons, and these several persons do not belong to a group which has been formed to assault one another reciprocally. Yet these several persons, attacked and assaulted one another reciprocally in a confused manner, and in the course thereof someone is killed. And no one had seen who was the actual perpetrator, who killed the victim, but there is a showing that someone has seen who inflicted serious physical injuries or inflicted any form of violence on the victim. In that case, the person who inflicted the serious physical injuries, or in his absence, the person who inflicted any form of violence on the victim who died shall be the one criminally liable. Because the actual person who killed the victim cannot be ascertained, cannot be established. That is death in case of a tumultuous affray. Under Article 252, we have physical injuries in a tumultuous affray. Again, there is a tumultuous affray. and a participant therein suffered either serious physical injuries or less serious physical injuries. And it cannot be ascertained who inflicted the serious or the serious physical injuries on him, but the person who used any form of violence on the victim can be determined, can be established. Then, that person who used any form of violence on the said participant shall be the one liable for the serious or the serious physical injuries sustained by the victim. Articles 251 and 252, death may tumultus affray and physical injuries may tumultus affray, will only apply if in the course of a tumultus affray, someone is killed or a participant is wounded with serious or the serious physical injuries, and it cannot be established, it cannot be determined who killed or who inflicted the serious or the serious physical injuries on the part of the said victim. Even if there is a tumultus affray and someone is killed or a participant is seriously or less seriously wounded, if the actual perpetrator of the crime can be established, Articles 251 and 252 would not apply. This will only apply if the actual perpetrator cannot be ascertained. In case of Article 251, death in a tumultus affray, the victim of the said killing, the one who died, can be any person. He can be a participant in the affray, he can be a total stranger to the affray, like a passerby or a mere bystander. On the other hand, in case of physical injuries in a tumultus affray, the law specifically states he must be a participant in the said affray. So there were these several people, several persons, and about 20 of them, they were fighting reciprocally one another in a confused manner on this big portion of the street. Each one was boxing one another with no particular victim, no particular assailant, just everyone boxing and kicking one another. W, a passerby, saw the incident. Instead of going to the store where he was told to buy something to run an errand, he stopped by as he was amazed by the fight. These people had no particular victims, had no particular intended persons. They just boxed and kicked one another reciprocally. Amazed, he stood very near the fight, looking intently. However, suddenly, X fell on the floor, fell on the ground. And a passerby saw that X has a wound on the chest. X was brought to the hospital, but because of too much loss of blood, X died. No one knows who stabbed the said accused on the chest. No one knows who killed the said accused in the course of the said tumultus affray. But the passerby saw that one of the participants in the affray, W, boxed his neck. Who shall be liable for the death of X? It is W. The one who inflicted any form of violence on the victim shall be the one liable for his death under Article 251, death in a tumultus affray. Reason is, the actual person who stabbed and killed him cannot be ascertained in the course of the said tumultus affray. Under Article 253, we have giving assistance to suicide. Just remember that giving assistance to suicide is not the same as euthanasia or mercy killing. In mercy killing, the offender who killed that victim out of mercy, if he is a stranger, should be liable for murder. If he is the parent, should be liable for parricide. Under Article 254, we have illegal discharge of firearms. There is illegal discharge of firearm if the offender aimed his firearm at another, discharges the firearm absent intent to kill. So in case of illegal discharge of firearm, there is on the part of the accused no intent to kill the said victim. Yet, he discharged the firearm aimed in particular at the said victim. Say, for example, it is a low-caliber firearm. And the victim, when he pointed the firearm, he knew the victim would not be hit because it was beyond the shooting range. Crime committed is illegal discharge of firearm.